India Legal presents Court This Week.
Hello and welcome to Courts This Week. I'm Heshe. In this special edition, we bring you top stories of legal proceedings from the courts, from lower to subordinate courts to high courts and the Supreme Court. We bring a selection of major legal proceedings which made headlines this week. In next half an hour, we will inform and update you on all important proceedings. So let's begin Courts This Week.
India Legal presents Court This Week.
The National Green Tribunal has imposed a total ban on sale and use of firecrackers in Delhi and adjoining areas starting midnight of November 9 to November 30th. The ban has been imposed ahead of Diwali to prevent worsening of the air quality already in severe zone because of firecrackers. The order will be applicable to more than 24 districts across 4 states that are a part of the NCR, and nationwide it will also be applicable to cities and towns where the average ambient air quality in November last year was poor or worse, the Green Tribunal has said.
The National Green Tribunal on Monday imposed a total ban on the sale and use of firecrackers in Delhi NCR region from midnight of 9th November to 30th November midnight. The NGT order further said that the ban will be applicable in cities and towns where the air quality is poor category. The NGT further added that in cities or towns where the air quality is moderate or below, only green firecrackers will be sold and time duration will be bursting them will be restricted to the 2 hours during festive season such as Diwali, Chhath, New Year, Christmas Eve as may be specified by the state. Currently, the state government have their own set of guidelines with regard to permitting, banning the sale and use of firecrackers during the festive season. The Arvind Kejriwal-led Delhi government at a meeting on Thursday had decided to ban the use of firecrackers as it was directly proportional to the sharp rise in the national capital daily coronavirus tally. At a time when the national capital is witnessing a spike in the number of coronavirus disease cases, bursting of firecrackers can aggravate breathing issue, thereby making people vulnerable to the infection which targets lungs. Shortly after the NGT order, the Haryana government allowed the use of firecrackers between 8 pm till 10 pm on Diwali and Guru Purab and 11:55 pm till 12:30 am on Christmas and New Year Eve. Apart from firecrackers, the rising pollution level in Delhi NCR can also be attributed to the expensive stubble burning. Delhi Air Quality Index continued to remain in the surf category for the 5th consecutive day. The AQI at 6 am on Monday was 459 and the minimum temperature recorded at 8.30 am. The AQI at 6 am on Monday was 459 and the minimum temperature recorded at 8:30 am was 10 degrees Celsius. An AQI between the range of 301 and 400 and 401 to 500 is considered to be very poor and serve category respectively. Bureau report.
And Republic TV's Arnav Goswami was granted bail by the Supreme Court in a 2018 abetment to suicide case. He and 2 others were arrested in connection with the suicide of architect Anvay Nayak and his mother. 2-judge bench of Justices D.Y. Chandrachud and Indira Banerjee pulled up the Maharashtra government over the TV anchor's arrest as they heard the petition through video conferencing. The Supreme Court said Arnav Goswami must cooperate with the probe, and the court also said that the release of the 3 must not be delayed by 2 days and asked them to furnish bond of 50,000 rupees. The Supreme Court had expressed a strong displeasure over the Bombay High Court order dismissing Republic TV editor-in-chief Arnav Goswami's bail plea in an abetment to suicide case and said high courts are not doing enough in matter where personal liberty is denied. And if a constitutional court don't interfere, we are traveling on the path of destruction undeniably. The hearing comes 2 days after the Bombay High Court turned down Goswami's plea against his arrest and the reopening of the case. I do not watch the channel, Justice Chandrachud had said earlier, but asserted that if Constitutional Court did not interfere, we are travelling to the path of destruction undeniably. Goswami's lawyer, Harsh Salve, had argued in the hearing, is Arnab Goswami a terrorist? Are there any murder charges on him? Why can't he be given a bail? The court had some tough words for the Maharashtra government too over the arrest last Wednesday on the TV anchor. According to the Mumbai police, Anvay Nayak, who designed the set of Republic TV, had left a suicide note blaming Mr. Goswami and 2 others for dues he alleged had not been paid to him. The Supreme Court affirmed the Calcutta High Court order banning the sale and bursting of firecrackers during Diwali, Chhath Puja, Kali Puja and others in the entire state of West Bengal. A vacation bench of Justices D.Y. Chandrachud and Indira Banerjee dismissed the special leave petition filed against the November 5th order passed by a division bench of the High Court in the brief hearing on Monday. Justice Chandrachud observed that preservation of life was more important during the COVID-19 pandemic than the celebration of festival. The judge told senior advocate Siddharth Bhatnagar that the counsel of the petitioner Gautam Roy, High Courts know the local situation better. Of course, festivals are an important part of our culture, but we are in the middle of pandemic. There can be no greater value than the preservation of life. We understand this may involve hardship, but look at COVID-19 affected people in hospitals, elderly people, etc. Can anyone step out of the house in Calcutta, Delhi or any part of other city today? But Nagar submitted that the High Court had no empirical data to arrive at the conclusion regarding the necessity of crackers ban. Justice Chandrachud disagreed with this view. Faced the disinclination of the bench, Bhatnagar made an alternate submission. Conceding to sustain the firecracker ban for Diwali, Bhatnagar urged the bench to reconsider the ban during the other upcoming festivals like Durga Puja, Kali Puja, Chhath Puja, etc. Following this brief exchange, the bench said that it was dismissing the petition. The Supreme Court had ordered that no unnecessary adjournment should be granted in criminal cases pending against legislators across the country. The court said that the Witness Protection Scheme 2018 should be enforced by the concerned courts. It also reiterated the earlier direction issued on September 16 regarding vacation of stay that may have been granted by the High Courts. The court clarified that these directions are applicable to cases involving both sitting as well as former legislators. The court noted in the report submitted by various high courts and the report submitted by the amicus curiae, some suggestions by the amicus curiae are: 1. For the efficacious disposal of these cases, robust video conferencing facilities and upgradation of infrastructure is necessary. 2. The tenure of judicial officer dealing with the aforesaid case is at least 2 years in order to ensure continuity. The court as of now issued the following directives. 1. Keeping in mind the public interest involved in these matters and in order to prevent undue delay, we direct that no unnecessary adjournment be granted in these matters. 2. At the cost of petition, it is clarified that the direction in the present writ proceedings are applicable to both sitting as well as former legislators. The court also directed the High Court of Kerala to furnish a list of cases to the Chief Secretary, Director General of Police, where the warrants are not being executed. The Attorney General for India, K.K. Venugopal, has granted his consent for initiation of contempt proceeding against comedian Kunal Kamra over his tweets about the Supreme Court in the wake of its order granting interim bail to Arnab Goswami, finding Kamra's tweet to be highly objectionable. The AG granted his consent under Section 15(1)(b) of the Contempt of Court Act 1971. To initiate criminal contempt, he said, I find that today people believe that they can boldly and brazenly condemn the Supreme Court of India and its judges by exercising what they believe is their freedom of speech. But under the Constitution, the freedom of speech is subject to the law of contempt, and I believe that it is time that people understand that attacking the Supreme Court of India unjustifiably and brazenly will attract punishment under the Contempt of Court Act 1972. The AG's letter referred to Kamra's comments such as honor has left the building long back and Supreme Court of the country is the most supreme joke of the country. The AG also noted that apart from these comments, Kamra posted a picture of the Supreme Court dressed in saffron color with the flag of the ruling party, the Bharatiya Janata Party. Taking strong exception to this tweet, the AG commented, "This is a gross insinuation against the entirety of the Supreme Court of India that the Supreme Court of India is not an independent and impartial institute, and so too its judges, but on the other hand is a court of the ruling party. The BJP existing only for the BJP's benefit." The AG had earlier declined consent to initiate criminal contempt against activist Swara Bhaskar for her comments criticizing the Supreme Court, observing that the comment did not amount to an attack on the Supreme Court. The Delhi High Court has ordered news channels including Republic TV and Times Now to ensure that no defamatory content against Bollywood personalities are displayed on their channels or uploaded on their social media handles. The court was hearing the suit filed by 38 Bollywood production houses against Republic TV and Times Now over sensationalized coverage of the Sushant Singh Rajput case, which saw the media channels making allegations of drug trafficking against various Bollywood personalities. During the hearing today, Justice Rajiv Shekdar recorded the assurances given by the media houses that they would abide by the program code under the cable television network rules. As the hearing drew to a close, the plaintiffs urged the court for a direction that the defendant media houses be restrained from carrying out a defamatory reporting in the interim, orally observing that this is not as if a person can say that they will not follow the law. The court proceeded to add in its order that the media houses should ensure that there is no defamatory content on their platforms. The court had issued a notice in the matter and posted it for further hearing on December 14th. And the Delhi High Court has expressed concern over a sharp spike in COVID-19 cases in the capital city and remarked that the Delhi government has remained oblivious to the ground reality and has thrown all caution to the wind. A bench of Justice Hema Kohli and Justice Subramaniam Prasad wrapped the government for continuously relaxing norms for movement of people, even when there has been an exponential rise in the positivity rate. A city-state like Delhi has been reporting far more cases than states like Maharashtra and Kerala. No household has been left untouched. However, it has been noticed that even in such a critical situation, the Delhi government has continued to relax the norms relating to the movement of people. The bench has therefore enlarged the scope of hearing in a petition filed by one Rakesh Malhotra seeking ramping up testing facilities in Delhi. The bench has now directed the Delhi government to file a status report setting out the steps taken by it in the past 2 weeks to control the COVID-19 infection and the manner in which it proposes to deal with the other issues flagged during the course of hearing. The court noted that despite worsening of the situation in Delhi, both due to COVID-19 and air pollution, the government had proceeded to increase the number of guests permitted at marriage ceremonies from 100 to 200. Similarly, as against the permission granted earlier to occupy alternate seats in public transport, the Delhi government permitted seat in public transport to be fully occupied. The court also made remark against testing through RAT and stressed that RT-PCR testing must be ensured. And the Madras High Court has ordered authorities to block the derogatory remarks made by former High Court Judge Justice C.S. Karnan on social media platforms, observing that the damage caused would be incalculable if derogatory remarks continue to be uploaded online. After hearing preliminary submission made by senior advocate S. Prabhakaran, a bench of Justice M. Satyanarayan and R. Himalata allowed the ad interim relief prayed for by the petitioner. Tamil Nadu Bar Council. In its petition, the State Bar Council had sought criminal and legal action against the former judge and had also prayed for an interim direction to block the URL of websites hosted by Facebook, YouTube and Google, which had shared the ill content and video featuring Karnan's derogatory remarks. The bench observed that the allegation being made by Karnan were prima facie highly defamatory. In the course of the order, the High Court also stated that it is rather unfortunate to note that Justice C.S. Karnan, who had held an important constitutional post, has gone down to such a level and repeatedly scandalized and made vituperative, obscene and unparliamentary attacks against judges of the Supreme Court, the High Court and their families. The court further noted that his tirade continued unabated, with allegations being made against female staff of the court and women lawyers as well, including a designated senior advocate. And describing the state of affairs as regard the people of tribal community within the state of Bihar as shocking, the Patna High Court last week expressed hope that the authorities wake up from slumber and come out with a structured plan for ensuring implementation of the constitutional mandate, including that under Article 338A. The said article provides for a National Commission for Scheduled Tribes. The bench of Chief Justice Sanjay Karol and Justice S. Kumar was hearing a PIL by the Bihar Adivasi Adhikar Forum, highlighting the apathy and policy paralysis on the part of the government in fulfilling the constitutional goal and the fundamental duty of providing education to the children, more specifically girls, hailing from the tribal areas falling within the hilly areas of District West Champaran. The bench proceeded to remind itself of the constitutional mandate provided under Part 4 of the Constitution of India, which promotes the educational and economic interest of the weaker section of the people, and in particular of the scheduled caste and scheduled tribes. The government had assured of dealing with the problem on a proactive basis, ensuring that not only the institutions are allowed to remain operational and functional, but also the general populace sensitized of sending the children, more particularly the girls, to undertake and complete their education at least up to higher standards, that is class 10 to 12 and even thereafter. A writ petition has been filed in the Allahabad High Court seeking removal of Mathura's Shahi Idgah mosque allegedly built on Krishna Janmabhoomi. The petition filed by advocate Mahek Maheshwari seeks that the temple land should be handed over to the Hindus and a proper trust for Krishna Janmabhoomi Janmasthan be formed for building a temple on the said land. In the interim, the plea seeks permission for Hindus to worship at the masjid on certain days in a week and on Janmasthan days. Till the disposal of the petition, the plea alleges that Lord Krishna was born in Karagar of King Khans and the place of his birth lies beneath the present structure raised by the Shahi Idgah Trust. It is stated that in 1968, the Society Sri Krishna Janmasthan Seva Sangh entered into a compromise with the Committee of Management of Trust Masjid Idgah, conceding a considerable portion of land belonging to the deity to the latter. Disputing the legality of this compromise, the petitioner has submitted the Committee of Management of Trust Masjid Idgah entered into an illegal compromise with the Society Sri Krishna Janmasthan Seva Sangh, and both had played fraud upon the court. The plaintiff deities and devotees with a view to capture and grab the property in question. In fact, Sri Krishna Janmabhoomi Trust is non-functional since 1958. She has further claimed that existence of carved pillars and antiques Below the courtyard of the Shahi Idgah Mosque was reported by certain workers. In this backdrop, a prayer is made for court monitor GPRS-based excavation by Archaeological Survey of India of the disputed structure allegedly built over Krishna Janmastan. And it is contended that masjid is not an essential part of Islam, and hence the disputed land should be handed over to Hindus for exercise of their right to freely profess, practice and propagate religion under Article 25 of the Constitution of India. And that's all for Courts Roundup today. Thank you for tuning. Keep watching APN for more updates from around the nation.
India Legal presents Court This Week.